Good morning, everyone. Welcome to today's hearing. Today we're going to start by hearing further evidence from Mr. Brian Moore. So my first task is to check that he is here with us and can see me and hear me satisfactorily. Good morning, Mr. Moore. Are you there?
Good morning, Mr. Chairman. Yes, I am, and I can hear you and see you clearly.
Very good, thank you. Well, today, as always, I'm joined by my fellow panel members, Ms. Istefan and Mr. Akbor, who are with me.
Good morning.
Good morning.
Mr. Moore, I think we better run through the housekeeping just for the form's sake before we actually start taking your evidence. So can I ask you to confirm that you're alone in the room from which you're giving evidence?
I confirm that.
Thank you. Can you confirm that you don't have any documents or other materials with you?
I confirm that.
Thank you. And finally, can you confirm that your mobile phone is in another room and that you don't have any other electronic device with you which is capable of receiving messages?
I confirm that.
Well done. Thank you very much. Now, the procedure today will be the same as it was yesterday. I hope we shan't have any interruptions. We shall, on the other hand, have a short break partway through the morning, around about 11:15. And as I told you yesterday, if you want additional breaks, just indicate and we'll do our best to accommodate you. All right. Anything you'd like to raise with me at this stage?
No, thank you.
All right. In that case, I'll invite Mr. Millett to continue questioning you. Yes, Mr. Millett, when you're ready.
Good morning, Mr. Chairman. Good morning, members of the panel, and good morning, Mr. Moore. Can I please ask for BBA 6047 to be displayed on the screen? BBA 6047. This is the BBA certificate for our Conics Rainabond 55 panels issued on the 14th of January 2008 that we looked at yesterday. And I want now to come on to your involvement relating to that certificate and ask you some questions about it in the post-fire time. But before we do that, I'd like to ask you one or two questions about the review and reissue processes in respect of that certificate starting in 2014. I'm going to summarize what we've heard so far. Valentina Amoroso told us that review number 2, effectively, of this certificate, S1/53729, started in October 2013 with an email from Maria Barbato from the BBA to Claude Schmidt at Arconic seeking information. And we heard, summarizing it, that both Maria Barbato and then Valentina Amoroso from December 2014 sent repeated messages of request to Arconic for supporting material on numerous occasions. We heard from Ms. Amoroso that come January 2015, having not received any of the information from Arconic, the subject of those repeated requests over some 16 months or so, she closed the review and went ahead with what information she held in hand to draft the review report. That's the summary of where we got to. Now, I want to show you, before I come to my question, what Mr. Nkomo told the inquiry yesterday, day 107. Can we please go to page 45 of day 107? He tells us that he would have signed off. I'm not sure it's actually on that page. Doesn't matter. Let me put to you what he told us. That he would have signed off to close the review with what we have, because that was the process that we were following. And then he said, if we're not getting all the information and we've been chasing, the instruction was you complete the review with what you have. Do you agree that there was a standing instruction to project managers to complete the review with what you have?
I don't recall there being a standing instruction. That in certain cases that wouldn't be appropriate, would it? So I don't believe that was the case, a standing instruction.
Well, you say in certain cases it wouldn't be appropriate, and it wasn't a standing instruction. In what cases would it not be appropriate?
Well, if there was just completely insufficient information available for a project manager to be able to make an assessment and a judgment, and what that might look like would depend on the facts of the case. But just logically, if one can't assess, then one can't assess.
Well, let me show you a little bit more of what was said by Mr. Nakomo. Can we go to the bottom of page 47, please, of his transcript? You can see that Mr. Nakomo is asked at line 12, were you aware of a decision, as she puts it, to go ahead with the information already in hands? Answer, I think I would have been aware of that, yes, because the report ultimately came to myself for checking and signing off. Yes. Question at line 18, Mr. Moore, can you see, would Valentina Amoroso have had the authority to make that decision? Answer, for Mr. Nakomo, not just Valentina. Generally, we would close the reviews if we were not receiving all the email. We wouldn't keep them open forever. You would just finish it up, make conclusions with what information you have, and close the job. That was common practice. Question, I see we will come back to that answer. I just want to know who was the decision maker, who would have had the authority to close the review with the information already in hand. Answer, in this case, I would have signed off to close the review with what we have because that was the process we were following at the time. If we are not getting all the information and we have been chasing, the instruction was you complete the review with what you have, and we closed the job with the decision, obviously, of what the information gives you. Now, I've shown you quite a bit there of Mr. Nakomo's evidence. Is that something you agree with on the basis of your experience at the time?
It would be not very usual that there isn't information to be able to make a decision on. Generally, that wouldn't be a satisfactory way to proceed. But I think I can read the sense of what Mr. Nkomo is saying, and I can see why you mentioned a standing instruction. If there was sufficient information for the assessor to be able to come to a view, then come to the view that you can. I'm not sure it's I don't believe there is a standing instruction to do this. There's a judgment to be applied. I think I can understand what Mr. Nkomo is saying, but I don't think it goes as far as being suggested it's a standing instruction.
Was there a general policy or common practice, to use his expression?
Well, the common practice, of course, is if you have sufficient information to make a decision, make it. And if you don't have sufficient information to come to a judgment, then don't make up. So I'm not being facetious, but I'm just saying that would be the approach that would be applied. I'm not sure it's certainly not an instruction, a policy, a common sense approach, perhaps.
Well, it may or may not be a common sense approach, Mr. Moore. What I'm seeking to get to the bottom of with you is, was it a policy or methodology or approach generally followed by project managers that even if they hadn't had answers to questions they'd raised from certificate holders, they would and could nonetheless proceed to close the review?
I would just say if they had sufficient information, if everything wasn't answered, then sometimes that would arise. They wouldn't get all the responses that they would want. But if they had sufficient information to be able to reach a decision and make a judgment, then do so. I would say it would be the approach. I can't describe that as a formal policy, as a way of sensible working.
Was there any guidance or any process for project managers and their line managers to follow if they were getting no response from a certificate holder to requests for information they thought were necessary or relevant?
If the information that wasn't available was so significant, such as the person was not able to make an assessment and come to a judgment, then escalate that, because there would be the decisions then about the ongoing validity of the certificate.
So would you have expected Valentina Amoroso or Prayer Nakomo to have escalated a repeated and long-standing failure by a certificate holder to provide information that they had asked for? Valentina, as the project manager at least, had asked for?
Yes, if the information was significant enough that Valentina or anybody else was not able to come to an assessment judgment, then yes, escalate that.
When you say not able to come to an assessment or judgment, do you mean, what do you mean, not able to come to an assessment or judgment?
If the information that they needed was important to the continuing validity of a certificate, and they didn't have that information, then yes, they should escalate that.
Would you expect a project manager to be pressing repeatedly for information that he or she did not regard as important to the review?
I would expect them to be pressing a lot for information they thought appropriate and necessary. Sometimes if they were just following by rote a list of things, perhaps some of those points aren't essential. But if they're pressing and pressing for something that they consider important and pivotal to the assessment decision and they weren't getting it, then yes, please escalate that.
And would those be circumstances in which suspension of the certificate should have been or would have been considered?
If the information that was sought was important and pivotal to the ongoing validity of the certificate, and the contractual position with the client would be that they have to provide information to us, then yes, that would be grounds for discussion as to whether suspension is appropriate.
Mr. Millett, forgive my interrupting. I think I would find it helpful if Mr. Moore could be asked to put this in context. We're talking about a review certificate, and the question is, how should the person concerned respond if the question to which he or she is not receiving an answer is, has anything changed? Because you've obviously got material already before you, because by definition it's review. But what you want to know is, has anything changed? Now, how do you respond if you don't get an answer to that?
Has anything changed? Well, that could be, it could be significant. Again, it would depend on what was known about the certificate, what the feedback from, if there'd been audits of it all. This didn't have to be seen in the round, but potentially it could be significant if they weren't getting response. But in some cases, it may not be that significant if we knew a lot about the product. So I'm sorry, it could be significant, but in some cases it may be less so.
All right, thank you very much. Yes, Mr. Millett.
Mr. Moore, let me try the chairman's question again on the basis that the request was for confirmation that nothing would have changed which would affect the validity of the certificate. What then if there was no answer after repeated requests?
Well, if in doubt, if the assessor or their manager feels that it is significant and they can't come to a reasonable and fair and objective decision, escalate it. If in doubt, escalate. I don't think there's any harm in escalating something to see if others can assist.
Well, you say you don't think there's any harm in escalating. What I'm really putting to you is, was there a system in place whereby if project managers refused, after repeated attempts to get confirmation that there were no changes which otherwise might undermine the validity of the certificate, the project manager and their line managers would escalate that to senior management?
So in terms of there being a document, a written policy of if after 2 or 3 attempts to get something you don't get it, escalate. No, I don't believe there. I don't believe, and I'm more sure than not that there is such a written policy.
And same question: was there a system in place whereby if questions such as that were repeatedly left unanswered, whether those would be grounds for considering suspension of the certificate?
Yes, if the grounds were significant and would affect the ability to make the decisions I've been talking about, that would be grounds for consideration of suspension.
Now, Ms. Amoroso told us that the only occasion when the BBA would threaten not to reissue a certificate is when the certificate holder would deny access to the factory. That was day 106, page 82 at line 6. Was she right about that?
No, I don't believe so. In my own experience, and certainly at or about 2016, I was dealing with a case which was not like that, where someone was either withholding information or presenting us with different information than we thought we should receive. I threatened suspension. I did suspend. So no, I don't think that was the only criterion upon which a decision to suspend would be made. Refusal to grant access to a location. I don't think that's correct, because I'm aware at least one and possibly more examples of where other grounds came into being and suspension followed.
Right. Now, you and Ms. Amoroso started at the BBA at more or less the same time, perhaps about a month apart. Can you account for why she told us that in her own experience and understanding, the only occasion when the BBA would threaten not to reissue a certificate is when the certificate holder denied access to the factory?
Well, with all due respect to Miss Amoroso, she may not be aware of what other parts of the BBA was doing, given there were a number of distinct teams, and there was generally often no need to share with individual team members what was happening elsewhere. So I don't believe she's correct in her assessment and assumption there. I'm aware of other examples which clearly are contrary to what she says.
Was it not important for project managers and their immediate line managers at least to have an understanding of what the sanctions were in circumstances where the certificate holder had not answered repeated requests for information relevant to a review?
Well, I believe it is clear that if you're not getting the information, you escalate it, and there are grounds to suspend if that's not the case. I'm surprised to hear that there was any other understanding operating, if that was the case for Miss Amoroso and indeed her manager.
Yes, and my question is, can you account for why she had the view she did?
No, I can't. And what I can say, just apply my mind to this, that there would regularly be staff meetings where all the teams were brought together and senior managers would discuss with them what was going on. And I can say that from certainly 2016 onwards, my presentations to staff at the BBA were about intelligence, getting information about anything unethical going on in the organisation, and about risk, escalating risk, and understanding the BBA's position in respect of having information that maybe only we would know about, and making sure that was employed and deployed properly to keep the public safe. So that was something I spoke to on a number of occasions during my time at the BBA.
Can you account for why there was no, or appears to have been no, clear guidance or training given to project managers and their immediate line managers about the exact circumstances in which suspension of a certificate would be considered?
Well, the grounds can be numerous and varied, of course. If there is an issue that's stopping you being able to do your job, escalate it, and let your managers and others worry about this rather than the individual. So I don't know why there isn't such a policy as you describe, but I'm just trying to think how practical that would be. But I never in my time at the BBA had a sense that people would choose to sit on and suppress risks for themselves rather than escalate it to people more senior.
Now, there was a further review of this certificate for Reina Bond 55, which began in October 2016. And I just want to ask you about one or two aspects of that review. Valentina Amoroso told us that she discovered that the cassette fixed variant of Reina Bond 55 was not manufactured by Arconic, and that as a consequence, it was treated, or to be treated, as not covered by the certificate. And eventually that led to its being excluded when the certificate came to be reissued in August 2017. And that's a summary of what she told us about the cassette. On the basis of what I've just summarized to you of her evidence, do you agree that she had identified a material error in the certificate as it has existed since 2008, namely that it covered cassette fix variant of Reina Bond 55 when it shouldn't have done?
Yes, that is significant.
Now, Valentina Amoroso told us that there was no process by which such an error would be communicated to readers of the certificate unless they specifically contacted the BBA and inquired. She said that in her statement at paragraph 86 and also at day 106, page 111 at lines 19 to 24. I don't need to take you to that, but is she right about that?
Yes. There was no direct process for the BBA to communicate with the public or users, and the responsibility would be upon the client to bring that to the attention of those who may be affected by it.
Does that tell us that certificates would or might still be circulating which had errors on it, like this one, and no one would know unless they asked?
Well, from the BBA's perspective, the BBA would not know who had used it, where it had been used, how it had been used. The certificate I'm referring to wouldn't have that information to be able to act upon it, but the client would. But I can tell the inquiry about one occasion where literally just 2 days before the fire, where I did do a major escalation to HM government of a matter that caused me great concern. So it was possible for the BBA to communicate or report to government if something was very significant and we were aware of it.
Can you tell us as shortly as possible what that matter was that caused you such great concern?
Yes, as briefly as I can. in February of 2016, the BBA became aware that insulation on the side of a building, a tall building, had fallen. Nobody was hurt, thank the Lord, but it did raise significant issues because that was a certificated product. And I dispatched a team to go and inquire what had happened. And as a result of what we learned, I mounted something like a 14-month inquiry, because it appeared that the industry was not very aware of wind load calculations, how robust something exposed to severe weather would need to be. And that investigation reviewed lots and lots of different certificates and certificate holders. And we presented our report about our findings, because I think it was out with the BBA's control and even out with the client's knowledge as to where this has gone. And we submitted this report to HM government on about the 12th, I think the 12th or the 13th of June, 2017, some 14 months after the incident. So the BBA could and would escalate matters if I knew about them.
And as a result of that investigation, was it prompted, first of all, by anything wrong with the certificate in relation to insulation?
No, I don't believe it was, because the responsibility within it was upon building professionals to make the right calculations. The issue was that I was not convinced, and my scientific and engineering colleagues weren't convinced that those skills reposed in the users of the certificate. So on that basis, it was raised.
Right, so it wasn't anything about the certificate that started this investigation. It was about the use of the end product. Is that what you're telling us?
To the extent that the certificate, to the extent that the certificate identified the responsibility with someone else, I wasn't happy that was sufficiently clear, which is why I explored it. And because it was about the end user and we couldn't control that, I escalated that to HM government.
Who at HM government?
To the Department for Communities, as it was then, and local government. I think the gentleman's name may have been Mr. Harrell.
Coming back to this one, can we just look at what you said a moment ago on page 15 at line 4? You said the BBA wouldn't know who'd used it, where it had been used, and how it had been used. But you would be able, wouldn't you, to put something up on your website to say to the world that the Renebon 55 certificate, dated 14th of January 2008, had a material error in it and no longer should be read as covering cassette. Why couldn't you do that?
I believe that there was a process whereby certificates which were withdrawn were posted onto the BBA website. I think it was, I remember seeing it. I didn't spend a lot of time with it, but I remember looking at it, that there was a withdrawn certificate page or area on the BBA website.
Right. Was there a process at the BBA whereby those who might have relied on an inaccurate certificate in the past were told about those inaccuracies?
Well, the answer is that the BBA wouldn't know who had relied on or seen or used a certificate previously. Therefore, it was difficult, other than to say a certificate had been withdrawn and placed onto the website as I've just described. I wasn't aware of another process. I can't think of another process that would answer the question that you've just said.
Well, why not put on the BBA's website that in relation to the 14th of January 2008 certificate for Renebon 55, it can no longer be relied upon as covering cassette and should never have covered cassette from the start. Why wasn't that something you could put on your website as soon as that was discovered?
Well, just, there could be a multitude of reasons why a certificate is withdrawn. Going on to how much narrative does one put around these things, but the fact the certificate had been withdrawn was there, and of course anyone can ask, why is that? So I think that was the approach that was taken. Report the fact. There could be loads of reasons around it, and then if someone wishes to find out more, to contact the BBA. That's, I believe, the approach that was adopted.
Right. My question is, why wasn't there a process whereby, as soon as Valentina Amoroso decided that the certificate should no longer cover cassette and should never have covered cassette, that fact wasn't communicated to the world at large on the BBA's website, whether or not the certificate was formally fully withdrawn?
I can't answer other than to say, as I've answered before.
Now, we've also heard that Valentina Amoroso asked Arconic, as part of this 2016 to 17 review, for technical data sheets, commercial brochures, installation manuals, and CE data. And we've also heard that at this point, late 2016, the latest fire classification report on the technical file available to her was from 2005. Against that background, my question is, was there a policy or process in place at the BBA at that time, late 2016, whereby project managers should routinely ask for up-to-date classification reports?
No, I don't believe there was such an instruction or requirement.
Why not?
The process that the BBA operated against was that the location should be under surveillance, and the obligation on the client to report anything that had changed, which we've just discussed. And therefore, if it was a sealed system, if you will, that if nothing had changed and the attributes of the product hadn't changed, then the extant information was sufficient to enable the BBA to be satisfied that the product was still as it was intended to be when certificated. That was the concept.
So you were entirely reliant on whether or not there'd been anything that had changed in the manufacturing of the product, its attributes.
Yes, and in my opinion, I believe that the BBA was and is overly reliant on the client providing information to the BBA.
Hence, would you agree, the critical importance of seeking and obtaining on every occasion of a review or reissue, a clear confirmation from the client that nothing had changed which would undermine the validity of the certificate?
In my opinion, yes, but I don't think the sanctions available upon a client are sufficient to make sure that happens.
Now, we know that in November 2016, the BBA offered a reissue contract to Arconic, and that was agreed. I don't need to go to that with you. The reference is BBA 408187. And we know that a reissue process was taking place when the Grenfell Tower fire occurred on the 14th of June 2017. I want to turn to some questions about ADB before I ask you questions about what happened after the fire within the BBA in relation to this certificate. So against that background, can I show you Mr. Albon's second witness statement, please? This is BBA 3010723, and I want to go to page 36. paragraph 149. He says, at the bottom of the page, under the question at 37, please explain what steps the BBA took to review and amend the BBA certificate 08/4510 after the fire and what precipitated those steps. And his answer is, earlier in 2017, before the fire, the BBA had identified what it considered to be an ambiguity in the wording of section 12.7, insulation materials / products of approved document B, volume 2. This section reads in part, if we can turn the page, please, in a building with a story 18 meters or more above ground level, any insulation product, filler material, not including gasket, sealants, gaskets, and similar, etc., used in the external wall construction should be of limited combustibility. And if we go down to paragraph 150, he says the issue centered on what would constitute a filler, quotes unquotes, and in particular whether the polyethylene materials in ACMs could be so classified. Since the events at Grenfell Fire, there has been some debate on this issue, and an opinion has been expressed by an expert witness to the inquiry, Dr. Barbara Lane, that this is not the case. However, the BBA felt that the existence of the etc. in this section widened the definition of materials covered by this requirement, and that it could be concluded that the polyethylene would be required to be of limited combustibility, irrespective of whether or not it constituted a filler. And then at paragraph 151, he says, if this was the case, as the polyethylene was not of limited combustibility, the product would be restricted to use on buildings up to 18 meters in height. Were you aware of this view that he has described at the BBA at the time he describes?
I can't remember exactly when in 2017. My feeling is it was linked to the time of the fire or shortly thereafter. But Mr. Alban and others were discussing this issue about the filler and the etc. wording. So yes, I was aware of the conversation. I can't tie it down to a specific time, I'm afraid.
Right. So are you unable to help us with exactly or even roughly when the BBA first identified the ambiguity to which Mr. Alban refers in paragraph 149?
No, I can't. I've got no reason to doubt that the timescale Mr. Alban has suggested as being in the early part of 2017. That may be correct, but I can't offer a personal view. It was certainly an extant discussion at the time of the fire, and I sense it may have been going on before then.
Right. Was this discussed at a senior level, a managerial level within the BBA, to your knowledge?
It's highly likely. It's a relatively small team. The CEO is an engineer and an enthusiastic engineer, and I feel yes, it would have been discussed at senior level.
Were you yourself involved in any such discussions?
I remember it being discussed. Whether that was a formal meeting or being talked about, I remember it, but I can't say that I was asked to make a decision or necessarily give a particular view on it.
Are you able to help us with how the BBA came to the conclusion identified by Mr. Alban in his statement here?
No, I can't. No, I can't help you.
Ms. Amoroso told the inquiry that the conversation or discussions about this question started at about the time of the second review, say late 2016. That was day 106, page 166, line 16, and page 167. Do you agree with that?
I'm sorry, there was an interruption in the transmission there, and I lost probably a third of the sentence, I think. Would you repeat the question, please?
Yes, certainly. Ms. Amoroso told the inquiry that the conversational discussions about this question started at about the time of the second review, so late 2016. I've given some transcript references. Do you agree with her?
I don't know is a simple answer. Again, the time, that is a possible time frame, but I don't personally know.
Can we look at your evidence yesterday, please, at page 107 of yesterday's transcript? Sorry, day 107, page 118 of yesterday's transcript. I apologize. Page 118 of yesterday's transcript. If you look down at line 11, you say, particularly during 2015 and into 2016, I began to take an interest in intelligence about the industry and making sure that anything that related to poor practice in the industry that was coming to our attention was brought to my attention so that I could decide how best to deal with it. Was this question about the meaning and ambit of section 12.7 of approved document B one of those things that was brought to your attention as a result of your interest in intelligence about the industry you told us about?
No, that's not quite what I was referring to yesterday. The intelligence was about unethical practice or malpractice that was taking place in the industry, not the legitimate debates about the meaning of the approved documents. I think there's been an almost near constant discussion about whether the building regulations and the approved documents are sufficiently clear. I think scientists and engineers who live and breathe this stuff talk about it a great deal. So I don't. That is not what I was referring to in line 11 of my yesterday's evidence.
Valentina Amoroso told us that the BBA had tried to reach out to the government on this question, but without much luck. Is that something you remember?
No, I don't. I can't say that I can remember that.
Now, I want to ask you about the aftermath of the Grenfell Tower fire, the immediate aftermath in the June and the July of 2017. Can I start, please, by taking you back to your witness statement at page 2? And you say on page 2 in paragraph 4, you say, I was in post on 14th June 2017 when the fire at Grenfell Tower occurred. In the aftermath, the BBA was trying to establish what had happened, but in my opinion, there was an information vacuum and the BBA sought to piece together a picture from media reports and other sources. We believe that Renebon PE was involved. Renebon PE is certificated by the BBA. Can you explain what you mean there by an information vacuum?
Yes. There was a mass of information swirling around. The media was full of reports, people who may or may not have been experts on the television talking about what had happened and what was involved, newspaper reports, social media. There was a maelstrom. But in the middle, clear facts from an authoritative and objective source, I thought was lacking. So I didn't know what had happened, and it was some time after it before I had a sense of what did actually happen. So we, like everyone else, were trying to understand what had gone on. So that's what I mean by a vacuum, but also a lot of other information flying around. It was difficult to understand what the position was.
Was there an internal investigation at the BBA in respect of this certificate at this time?
An internal investigation to the extent of understanding what had gone on and what was certificated. Yes. Yes.
Who led that investigation?
I would say that was me.
When did that start?
Again, it depends. It depends what you mean by an investigation. Can you just explain what you mean by internal investigation?
Well, you've said that it was an information vacuum and nothing at the middle of it, this maelstrom. I asked you whether there was an internal investigation in respect of the certificate. And you said, to the extent of understanding what had gone on, yes. So you tell me, what steps did you take to investigate the BBA's role in certifying the product that you rightly thought was on the outside of Grenfell Tower?
Well, I've set out in this witness statement the steps I took to establish what had happened in terms of what was on the building and who knew what and when. Can I just say and make it very clear that the purpose of this witness statement was to alert the inquiry in 2018, November, that Dr. Lane, who was about to give evidence to the inquiry, may not have had the information she needed. So this statement set out what I did and what I knew about in terms of what had gone on around what was on the building and the steps that the BBA took. So this document, in effect, reprises what I was doing to investigate what had gone on at the building.
Right. When you started your investigation, as you described it thus far, were you responding to a request from more senior management at the BBA?
Well, with respect, I think that the use of the word investigation was yours. I will agree to an extent, but perhaps not as far as you intended to mean. At the BBA, yes, the chief executive, of course, was fully aware, as were the governing board, and yes, I just put myself in a position of leading on behalf of the BBA.
Can we look at BBA 3010485, please? Now, if we look at the lower part of the screen, there's an email. Sorry, we need to go, I think, back to the top of the screen there. This is an email from you of the 20th of June. I think I need page. Yes, no, that's the one. And it's an email. No, I want the second email. I'm so sorry. I want the next page down, please. Second email in the string, 9:38. Yes, thank you. This is from you on the 20th of June, 2017 at 9:38 to a variety of people. And it starts, "Dear board members." Do I take it from the introduction there that the people to whom you were sending this email were members of the BBA board?
Yes.
Please find appended a note regarding the fatal fire at Grenfell Tower. This is our current understanding based on media reports. In summary, we are in a reasonable position. If the cladding system, i.e. the combination of cladding and insulation, is as described in the media, then the system is not certificated by the BBA. The insulation itself is not certificated by the BBA. The cladding itself is. The certificate is 2008 vintage and was in the process of being reviewed and reissued just before the fire. We would be in a stronger position if it stated in terms not to be used above 18 meters, but as the note makes clear, the certificate holder / user must comply with building regs. We had not conducted any cladding related inspections at building. Now, by 2008 vintage there, what were you indicating?
That the certificate was probably 8 years up. Well, it would be 9 years old at the time when the cladding, etc., the building had been and was being reviewed. Well, as it says there, and was being reviewed and reissued before the fire. it did not specify not to be used above 18 metres. Well, just as the note says, the certificate holder, however, must comply with building regulations.
Yes, sorry, you just gone off slightly off the point. I'm just asking you about the vintage. Did the fact that you were using the expression 2008 vintage indicate, or was it intended to indicate that this certificate was old and should perhaps have been reissued since 2008?
Yes, I think that is what I was saying. Vintage generally means that it was an older certificate. That's for sure.
Yes, and you say, as you see here and you pointed out, you would be in a stronger position if it stated in terms not to be used above 18 metres. Was it your view at the time that the certificate should have said that?
Well, I think, as you alluded to earlier, sir, that sorry, I've lost my point. That approved document B and fillers, etc., were causing the BBA to reconsider whether cladding with a PE core could be used above 18 metres. So to that extent, it was relevant to the BBA's thinking at the time. Forgive me, but it may help if you just repeat your question, please.
Yes, my question was it your view at the time that the certificate ought to have been restricted to use below 18 metres?
It would have been, well, it would have been clearer if it specified that in absolute terms. But back to the base upon which doing that, because approved document B, I think at that stage, still permitted B and class naught above 18 metres.
Well, indeed. And that was my next question. Was there anything that remotely suggested on the face of this certificate that RAINA 155 should not be used above 18 metres?
As I say, to your point earlier, that there was discussion going on within the BBA about limiting what we would certificate, i.e. to 18 metres, if the core was a filler and was potentially therefore not combustible or of limited combustibility. So it was that point which we discussed earlier, I believe. But again, I don't remember seeing that email until just presented. So forgive me if I'm trying to recall as I'm reading.
Now, we can see the note that was attached to your email of the 20th of June that we've just looked at. And the note itself is at BBA 3010486. I think in the light of the answers you've given so far, I can take this document quite quickly. But let's just look at it because it's a document with your name on it. It starts, BBA position on Grenfell Tower as of 20th of June 2017. And if we go to page 5 of that document, please. You can see your name at the bottom, together with John Albans and Jordan Adams's. Did you co-author this document?
I think probably the document came to me, and I put, I think, any board-related comments about it. So yes, I've added my name, so I am taking responsibility for the document.
I see. Can we go to paragraphs 16, 17, and 18 on page 3. You can see that those paragraphs there, 16 to 18, deal with technical matters about approved document B. You see that? Paragraph 17 refers to diagram 40. Paragraph 18 refers to section 12.7 of approved document B. And paragraph 19 refers to Appendix A and the meaning of limited combustibility. Were those passages that I'm showing you there, passages in this note that you wrote, or were they written by the other signatories?
I would have deferred to Mr. Alban on this. So I did not write that section.
I see.
I can't see all of 19, but I don't believe I would have authored that as well.
I see. So we can ask Mr. Alban about that, can we? I mean, would Mr. Alban be the better person to ask about the details of these paragraphs?
Yes.
Yes. Then we can move on to your discussions with Arconic in the June of 2017 after the fire. Can we start with BBA 3010769 at page 6, please? This is Simon Rowe's email to Nicholas Remy at Arconic, copy to Claude Verlet, Valentina Amoroso, and you. So it's 2 days or so after the fire at the Grenfell Tower. And you can see there that in the second part of the email, halfway down your screen, he says, if possible, we would be grateful if you could confirm that Arconic Architectural Products SAS supplied Renibond cladding panels to either of the above companies for this contract, and if so, whether panels standard or FR grade, polyester or PVDF coated in flat or cassette form. Thank you in advance for your help. Now, we've seen no response from Arconic to this email in our records, Mr. Moore. Do you know whether one was received?
To the best of my knowledge and belief, no response was received to this email.
Do you know why a response was not chased up?
A response was chased up. Colleagues, Mr. Rowe and Miss Amoroso, were, to my knowledge, calling Arconic, their contacts there, probably over a 2-week period.
We certainly see some correspondence in July, but I'm not sure we've seen a prompt email from Simon Rowe to Nicholas Remy or Claude Verlet saying, please can you respond to my email below? We haven't seen something like that. Do you know why that was?
Well, the staff members were chasing. I use that word. We were very keen to get information. I would imagine that the people at the other end were very, very busy. Whether they would be responding to emails or not from the BBA, clearly not. But we did have named people and telephone numbers. So there was work going on to try to telephone them as well during this period, to my knowledge.
Let's move into July 2017. Can we look, please, at MET 30's53158_P18, page 174. And here we see an email, second email down, I think, from Hannah Willis at BBA to Nicholas Remy on the 4th of July 2017. Dear Mr. Remy, on behalf of the BBA Operations Director, Brian Moore, please find attached a letter relating to the Grenfell Tower fire. You see that?
Yes.
And the letter itself is at page 181, a little bit lower down this exhibit run. If we can just go to that, please, page 181. And here is the letter from you, as you can see at the bottom of the screen, addressed to Mr. Remy at Merksheim. Dear Mr. Remy, Grenfell Tower fire. And in the second paragraph, the first paragraph, actually, I should just show you. You say, further to my letter of the 26th of June 2017, I write enclosing a copy of a letter we sent to over 600 local authorities and housing associations on Friday, 30th of June 2017. And I'll come to that in a moment. The background to this, you say in your second paragraph, is that we have been receiving inquiries from local authorities and housing associations asking for information regarding the role of certificates, in particular relating to the fire performance of aluminium composite cladding materials. We wrote to try to help staff in these organizations understand how to use and navigate BBA certificates. And I'll stop there. Can we look at the letter to which you're referring in the first paragraph? This is at page 175 of the same exhibit run. We can go back to that. If you look at the next page, we can see the actual letter. It starts, to all local authorities and housing associations, and there's a dear blank, aluminium composite cladding, understanding the role of BBA certificates, and it then proceeds. I'm showing you the first page there. Were you involved in the drafting of this document?
Probably not. If there's a significant technical element to it, then it would have been drafted on my behalf. Yes.
Well, let's just look at a separate document to see if we can explore that a little bit further. Can we go, please, to BBA 3010354? This is an email at the bottom of the page to you, I think, from Liz Mail. Dear Brian, sorry for such a late response this evening. Well done on pulling together this draft. Writing to LAs/HAs is definitely the right thing to do for all the reasons you state below. And because it also supports the BBA's ongoing efforts to create dialogue, build brand awareness, and prompt closer relationships with social landlords for the longer term benefit of CAST, CIT, etc. And then she says she's made quite a few suggestions to the text of the letter. But then if we go up a little bit up the screen, we can see that you are copied in on an email from Claire Curtis Thomas to Liz Mail in response. Liz, very good. John, read the point about building control. Is there any role here for competent person self-certification, which would diminish the input of the building control? And you're copied in on that, as is John Albon. And clearly that question is addressed to him. It looks from that as if you were involved yourself in the drafting of this document. Is that right?
Sorry, which document? The Q&A document?
Yeah, yes, the Q&A document. The 600, the letter that was sent to the 600 local authorities and housing associations.
Again, I don't remember this till you've just shown it to me. I haven't read the document, so it's difficult for me to comment. What I would say is if it contains significant technical information, then it's unlikely I would be drafting it.
This document, let's go back to it, shall we? It's page 176. Sorry, yes, page 176. Is this the document that you would refer to as the FAQ document?
No, I saw Q. I saw Q and I saw A, so that's the document. I was referring to this document. Yes.
Right. Well, let's stick with it for a moment. Can we go to page 177? And the question there is, what does approved document B say about cladding on high-rise buildings and what fire tests are carried out? It's at the top of your screen. And the first few paragraphs under that heading set out the requirements in approved document B and also requirement B4 on external fire spread, as you can see. And at the bottom of the page, just on the screen at the moment, if we can have it scrolled up just a little, it says, as a consequence of the testing carried out, the Renabond cladding product used at Grenfell Tower was deemed to achieve a Class 0 rating. Did you play any part in drafting that sentence?
I don't believe so. Again, looking at it's quite. I would not claim that my knowledge of approved document B and its appendices, etc., is sufficiently adequate that I would like to draft a document going out to 600 local authorities. So I don't believe I was involved in that, to the best of my knowledge and belief.
Do you know who was?
It would be those with the best knowledge at the BBA around this, possibly Mr. Alban, possibly Mr. Denyer, the principal scientist, or the chief engineer. But again, I am not sure. I don't wish to mislead the inquiry. I'm not certain.
I don't think we've seen John Denyer copied in on the email chain internally, which attaches this document. So do you know who drafted the sentence I've just shown you, or can you not help us?
I can't help you. I don't know.
Are you able to tell us what the words "was deemed to achieve class 0 rating" was there?
Sorry, you broke up slightly the last part of your question. Could you repeat the question, please?
Are you able to tell us what the words "was deemed to achieve class 0 rating" means?
No, I can't.
Do you agree as a fact that Rainer Bond P, he had not been tested in accordance with BS 476 Part 6 and 7, nor indeed BS 476 Part 11 for limited combustibility?
I believe that is correct.
Did you know that at the time this letter was drafted and sent out?
It's difficult to say. I don't know exactly when I would have known about this document in relation to that discussion. What I can say is that expression looks familiar. Was deemed to achieve a Class O rating. I don't know where it's from, but I believe I've seen that expression used before. So whether it was something extracted from another document, and I also think it's about this. The class naught and the Euro class are different, but they can be used. They can be used to satisfy the requirements of the approved document. So I think I've seen that wording before, but I can't say exactly where. And I think it's about trying to suggest they're equivalent, but of course they're not.
Well, of course, as we've seen, and we may need to go back to it if necessary, but the BBA certificate issued in January 2008 said that the product may be regarded as having Class 0. Given that you are at least passingly familiar with the certificate, does that help you with your recollection of the origin of that expression, deemed to achieve Class 0 rating?
Well, it's not exactly the same, is it? But it's a similar theme about whether these things are equivalent. But that expression did seem familiar, and I don't think it's that allusion that you've just made.
Can we go back to have the document, please, on the screen? Do you agree? Just look at them again. At the bottom of your screen there, do you agree that those words might lead the reader of this letter to think that Rainer Bond 55 PE had actually achieved Class 0?
Well, if one reads the paragraph immediately above it, and which I hadn't read a moment ago, I think that sets the context for it. Let me just read that again. These two rating systems are based on different tests which are not interchangeable, but the regulations accept the use of either system. To achieve these ratings, the whole cladding panel is fire tested. As a consequence of the testing carried out, the Rainer Bond cladding product used at Grenfell was deemed to achieve a Class O rating. It's possible. It depends whether the reader of this document, local authorities, would have building specifiers and engineers and others engaged in this. I hope it would make sense to the informed reader. But there's something about the paragraph above which I think sets the context a little.
Do you know when the BBA first became aware that Reynobond PE 55 had not achieved class 0?
I would say the only realistic time that I was sure, not suspicious, but sure, was probably Dr. Lane's evidence and report, which I think was in October 2018.
Now, I'm going to come back to the correspondence that you had with Arconic shortly. Before we do that, can I look first, please, with you at BBA 3010152? This is about the UCAS visit that took place in July 2012. And it's an email chain between you and Claire Curtis Thomas relating to that visit. If we go to the third email down, which I think you will find on page 3 of this exhibit. Yes, you'll see there that there's an email from you to Claire Curtis Thomas at 10:40, and you say Claire A. You see that? This morning's coordination forum. Do you see the document?
Yes.
Yes. We recommended that a message is placed on the intranet accurately but positively describing yesterday's visit by UCAS. Our reasons are, and then you can see the reasons set out. The second one, we have at least one member of staff who has vigorously challenged our position stroke handling. And then the third bullet point, one newspaper contacted us about an employee whistleblower. What was the nature of the challenge by the member of staff referred to?
I think we touched on this yesterday, sir. As I said yesterday, I can't remember exactly what the nature of the challenge was, other than he was very exercised about this. And I was concerned that following that, we knew that an employee had contacted a newspaper, so I assumed it was the same person. As per yesterday, I can't remember exactly what it was about. It was quite soon after the fire, and therefore it must relate to the fire. But I don't know. I don't think I ever was so closely involved in it that I knew the detail of what he was so anxious about.
Yes, and you did mention this yesterday at day 107, page 148, line 2. No need to go back to what you said. Let's go to a document and see if this helps your recollection. Can we please go to BBA 409596? And you can see that this is an email from Richard Beale to you and John Albon and Simon Rowe on the 6th of July 2017. It starts, one of our employees has raised some concerns relating to FAQs regarding Grenfell Tower. I'd like the team to look at the detail and offer a response against each of the points raised for me to directly liaise with the employee. Points raised, and then you can see there are 3. 1, certificate is subject to regular 3-yearly reviews is correct but misleading. A, reissues that should have been carried out have not been undertaken, so certificate is out of date, i.e. certificate refers to building regulations and NHBC regulations which are out of date and does not refer in any way to updated regulations. 2, no significant regulatory change which leads to certificate change, false. A, there have been a number of regulatory changes since 2008 which would have led to a change in the certificated, I think that should be certificate, being updated and changed. For example, following review of report S153729 in 2014, in which the BBA sent report and contract which highlights regulatory changes. The contract was not followed up and thus certificate was not updated. Web statement gives the impression that the certificate is up to date. 3, statement referring to the fact that BBA certified Reynobond product is fit for purpose on high-rise buildings as per manufacturer's definitions. A, BBA certifies that the product can be used in high-rise applications. BBA choose to use building regulations as applicable fire standards despite high-profile failures of related products in areas of fire safety, particular alley bond. FAQ statement implies that BBA must use building regulations for certification. This is incorrect because BBA choose the standards that BBA wish to apply certification to. BBA is an independent body, but not bound by government regulations in any area. BBA adopted these regulations despite concerns from industry about the appropriateness of the regulations. In essence, statement is inaccurate. Were these the complaints about the BBA's handling of the situation after the Grenfell Tower fire made by the employee who you believed contacted UCAS and the press?
Yes, I believe that is the case.
Now, you said yesterday that you didn't remember the specifics of the complaint. It seems to be that the complaint was, in fact, about the FAQs, in respect of which you had a hand in the drafting. Is that right?
Which the FAQs referred to just now?
Yes.
So could you just tell me your question, please? Sorry, I was reading the document again. Forgive me.
Yes, of course. Yes, of course. Do you accept that the complaint that was made by the employee, identified by this email, was about the FAQs, authorities and housing associations, which you had a hand in drafting?
I'm not sure, because there were some other FAQs which were on the website. So I think the FAQs you just referred to were specifically to local authorities who, of course, had high-rise blocks, etc., for a specific audience. But I think there were some other FAQs on the BBA website, because, of course, there was lots of contact from other people coming to the BBA, and it was hoped that the FAQs would help them, but also save, resource within the BBA. So I'm not sure whether this relates to the FAQs to the local authority or to any other FAQs that were on the website.
Right. Do you agree? Let's assume for the moment that these are the FAQs on the website. And let's assume for the moment that the statements referred to are correct. Do you agree that the FAQ was misleading for the reasons set out in this email?
But of course, at this time, which was the date of that 6th of July, the 4th of August certificate for Rayner Bond was almost certainly its final approved draft stage and about to be published, which I think dealt with many of the issues described there.
It's not quite an answer to my question, Mr. Moore. I'll ask it again. Do you agree, on the basis of this email, that the FAQs on the website were misleading?
No, I can't readily agree with that. Which FAQs are you referring to, and are they ones that I've seen? Are they the ones you showed to me earlier?
Well, okay, let's just take this a little more granularly then. Item 1, certificate is subject to regular 3 early reviews. Is correct but misleading. And then Mr. Beeler's put in underneath why, in his view, it's misleading. He says, reissues that should have been carried out have not been undertaken, so certificate is out of date. Now, is he right about that?
No, because at this time, the certificate for Rayner Bond, if that's what we're talking about, is actually being updated and made correct. Research that should have been carried out have not been undertaken, so the certificate is out of date. I'm not necessarily sure I agree with that.
Well, you may not have known this, but as a fact, the certificate wasn't reissued until the 4th of August 2017, so had not been reissued.
Okay.
It would be right, wouldn't it, to say that in saying that the certificate is subject to regular 3 yearly reviews is correct. That is right, but it was misleading because reissues that should have been carried out haven't been undertaken, so the certificate is out of date. Do you accept that?
Well, if what you've just said is correct, then yes, I'm sure what you said is correct.
Yes, well, just on that then, can you explain why the BBA's website contained misleading statements?
Well, for the reason I've just explained, at this time, the 4th of August draft is, in fact, it must have been at final approved draft stage, which means it had been agreed by the client. And I don't think the FAQs went into any granular details, just describing the process. Again, I've seen this document a couple of minutes ago, so forgive me if I don't have all the detail in my hand. I'm talking about the impression it creates for me. I don't think it went into great granular detail. It was intended to explain the process, I believe, and help people understand, navigate the certification process. I think it's actually written somewhere.
Mr. Millett, I'm not sure we've actually established that the information on the website was as you're suggesting. The impression I haven't checked the transcript, is that you invited Mr. Moore to assume that this was correct.
That is the basis on which we're proceeding.
Well, of course, if we assume it's correct, then it's correct. But his point is that it may, well, my question is it fair to put to him that the information on the website was incorrect if we don't know what was actually there?
Well, there it is, Mr. Chairman. It's probably a convenient moment for a break. I'll review what other questions I've got on this document, and maybe we can take them.
Well, all right, you have a look at that over the break. But it seemed to me that the questions were in danger of becoming circular because we were assuming the answer to the question.
Yes, I think the premise of my original question was that the document we looked at with him was the FAQs, but clearly if that's not right, then we can move on, perhaps. I'll have a look over the break. This may be a convenient moment.
Yes, I'm sorry to have interrupted you, but since I have, then this probably is a good time. So we will take the break now, Mr. Moore. We'll come back at 20 to 12, please. And as I said to you yesterday, please remember not to speak to anyone about your evidence or anything relating to it over the break.
I understand.
Thank you very much. 20 to 12, then, please. Welcome back, everyone. We're going to continue now hearing evidence from Mr. Moore. I'm just going to check that the communications have been established again. Hello, Mr. Moore, are you there?
Yes, Mr. Chairman, I am.
And you can see me and hear me, I hope.
I can see you and hear you clearly.
Thank you very much. And ready to go on then, I hope?
Yes.
Right, thank you. Well, then I shall invite Mr. Millett to put some more questions to you.
Yes.
When
Thank
you're
you, Mr. Chairman. Thank you, Mr. Chairman. Mr. Moore, I'd like to ask you now about the topic of the suspension of the Reynolds certificate after the fire in July 2017. Can we go to BBA 301048? Now, this is an email from Claire Curtis Thomas to you, and if we can have it blown up on your screen, you'll see it more clearly. On the 10th of July 2017 at 7:53, also to John Alban and Simon Rowe. Subject, Reynolds suggested Q&A, attachments, Reynolds suspension questions doc. And the text says, my apologies if you've already received this. I am in double email world and wanted to make sure. Let's look at the attachment. It's at BBA 3010429. Now, this is a Q&A, as you can see, and it starts with the first question: why has the BBA suspended the Reynolds certificate? Do you know who the intended audience was for this document?
I'm not sure. I would imagine this would be outward facing. So to people outside the BBA. But I'm not certain. There was a lot happening at this time. But I suspect it was what would be our position if we suspended the Rayner bond certificate.
I see. So the public, anyone who asked, anyone who was interested.
Possibly, yes, yeah.
Let's look at the first Q&A. Q, why has the BBA suspended the Rayner bond certificate? A, we've been attempting to contact the certificate holders since the Grenfell Tower fire to establish certain facts. We provided a date by which we expected a response, and that date has passed. In the absence of receiving the information, we require the BBA but believes that it has necessary and proportionate to suspend this certificate. And let's go down also to the third question relating to the implications of suspension, which says, what are the implications of the Rayner bond certificate being suspended? And then if you go down to the answer, it says, it means that the manufacturer cannot claim that this product is certificated by the BBA. Further, that building and construction product professionals such as architects and designers will not have the independent assurance afforded by the BBA's certification as to the product's performance. However, the suspension of the Rayner bond certificate does not mean that all previous installations of the Rayner bond product are, quotes, at risk, close quotes, provided that previous installations were executed in accordance with the requirements of the certificate and undertaken by a suitably qualified and experienced person. Do you agree, just looking at that in fact, previous installations would be at risk if the claims regarding fire performance made in the certificate were not accurate and had never been accurate?
Yes, I would agree with you.
And similarly, if statements in the certificate relating to building certification were out of date?
Sorry, say that question again, please. I'm sorry.
Yes, I try it differently. Would you agree that, in fact, installations would be at risk if statements made in the certificate about compliance with the building regulations had become out of date or wrong?
If they were out of date, possibly less so, but certainly if they were wrong as a result of any changes to building regulations, that yes, I would agree with you.
Yes. So would you also agree that executing installations in accordance with the requirements of the certificate, where that certificate overstated the product's fire performance or misstated the product's fire performance would be no guarantee at all that the installation was safe.
Yes, that follows. Yes.
At this stage, is it right that you hadn't yet got to the bottom of the accuracy of the claims made in the BBA certificate relating to compliance with the building regulations so far as regards fire performance?
I'm not sure I understand what you mean. Had got to the bottom of, what do you mean?
Is it right that at this stage the BBA had not completed its investigation so as to satisfy itself that the claims made in the certificate for fire performance of Reynabond 55 PE were correct?
That is correct.
So if that is correct, why are you making the statement that we see in the second half of the answer that I've just read to you?
Well, I don't know the provenance of this document at all. I can't remember seeing it before, but I'm sure it's just been produced before me. I don't think it was ever used, and I'm just not sure why and how it's been constructed and what the purpose of it is. Clearly, at this stage, as we discussed earlier, the BBA was trying to make contact with Reynabond to establish the position, and yet suspension was likely to follow if there was no follow-up. But beyond that, I don't know who has written these responses and whether they were fully cited on all the facts and circumstances. I don't believe this document was ever employed or deployed to anybody.
We can see that you saw it at the time because I took you to the email. Can we take it that you did see it at the time?
Well, yes, if it's copied to me, whether I examined it or not in detail, I don't know. This does not seem to be a document that featured in anything subsequently.
Right. Well, perhaps you could just help me with this. Can you explain why the BBA was preparing to give assurances such as we see in the second half of that answer without yet having heard anything from Arconic or investigated the fire performance statement on the certificate?
Well, again, I think if there's a timeline, we'd see where this fitted into contact with Arconic. It would be not unreasonable to project ahead, but this document is not authoritative at all. And I'm sure there was various pieces of thinking going on at the time. It was a very busy time, and I certainly don't. I took no regard to this document at the time, probably, or certainly subsequently. It hasn't influenced me, as far as I can tell, in any way. So I don't really recall it. It wasn't significant.
Were you still the operations director at this time, or had you yet become a deputy CEO?
On the 10th, what was the date? If the date was on or about the 10th of July, no, I was the ops director.
Were you, in that capacity, were you not interested in understanding exactly what it was that the BBA was going to tell the public about the suspension of the BBA certificate?
Yes, of course.
Yes.
There wouldn't be a suspension of a certificate in these circumstances without me being closely involved and making sure everything was correct. This seems to have come from Claire Curtis Thomas, if I'm right. And Claire was not very, very closely involved in this. So her understanding and knowledge of the detail, I with all due respect to her, was not very precise at that time.
And no doubt, as a conscientious operations director, you would have wanted to make sure that whatever was going to be said to the public by way of explanation of the suspension of the BBA certificate was entirely accurate and correct. Is that right?
To the best of my ability, the BBA would not mislead the public or indeed anybody. and I wouldn't allow anything to go out to the public realm. If I could, that would lead to that outcome. So
Yes.
I don't think this document was significant.
Well, did you think at the time when you received it on the morning of the 10th of July 2017 that it was an insignificant document that didn't warrant your attention?
Well, it's difficult to say. I can't actually recall reading it. What are there messages either side of it? Was there any indication as to what happened to it? I literally do not recall this. So that's why I don't feel great weight was attached to it by me or anyone else.
Well, let me just try the question again. Can you explain why the BBA, on the face of this document, was preparing to give assurances like this without, as at the 10th of July, having heard back in full from Arconic in response to the BBA's questions, or investigated the truth of the claims about fire performance made in the certificate?
I can't explain why that would be, other than if it was written by Claire Curtis Thomas, she wasn't blessed with all of the facts. And the sentence, however, suspension of the rain bond does not mean that all previous installations of the rain bond product are at risk, provided that previous installations. Again, at this stage, I didn't know what was on that building, and whether, personally, I didn't know what was on there and whether that statement was correct or not. So it's very difficult, and this document couldn't have gone anywhere because I don't think anyone truly understood the position at the time. It's clearly for discussion, but as I say, I don't believe it went anywhere, and I don't believe any member of that team would have allowed an inaccurate document to go out into the public realm if it could be avoided, and to the best of our knowledge.
I'm bound to suggest to you, Mr. Moore, that it was irresponsibly risky for the BBA to make a statement like this in circumstances where it had not yet fully satisfied itself of the accuracy of the statements made about fire performance in the certificate. Do you accept that?
Well, no, I don't think necessarily I do agree with that. This document, I don't believe, went anywhere at all. I don't believe it's particularly accurate. I don't believe it's sufficiently nuanced. It's in the middle of our attempts to contact Rayner Bond. So no, Claire Curtis Thomas may just have been simply mistaken. The key thing is that nothing, to the best of my knowledge, happened to this document. It clearly wasn't right, so it didn't go anywhere, to the best of my knowledge. So I don't think I agree with the assertion.
To your knowledge, did anybody tell any of the recipients of this document or Claire Thomas that the statement made in the second half of that answer was one that the BBA could not and should not make?
Again, can I see the circulation list again, please?
Yes, you can. We need to go back to BBA 430-10428. And it's on the screen in front of you, Mr. Moore. Does that help?
So of those names, Mr. Alban knew a lot of the detail. Mr. Rowe knew a lot of the detail. Mr. Webb and Mr. Beale didn't know the detail of this. They wouldn't entertain doing anything with the document. And Claire Curtis Thomas, again, wouldn't know great detail. So I am sure, because I'm sure you'll tell me if it's the case, that this document wasn't circulated. I don't remember the detail of telling Claire Curtis Thomas this is wrong or incorrect, but it wasn't an authoritative position piece for the BBA at that time. So to answer your question, no, I don't remember telling Claire Curtis Thomas this is wrong, but I can say it didn't have any weight or significance.
Let's turn to a different topic. I'd like to ask you to cast your mind back to a little bit later in the story, January 2018. Can we go to your statement at BBA 50159, page 4? Let's look together at paragraph 11. You say, on Monday, the 29th of January 2018, I met Tom Simons, a BBC journalist, at our offices and was informed by him that the BBC had information which suggested that a change had been made to the core of the Reynabond PE product in 2015. And Mr. Simons was inquiring about whether the BBA was aware of this. I said that we would look into the matter. In the days following that meeting, my inquiries at the BBA indicated that we had no record of being informed of any change to the Reynabond 55 PE core in 2015 or thereafter. Were you told by the BBC what change or changes had been made to the core of the Reynabond PE product?
Yes.
What?
Mr. Simon had with him an email document, which he was carefully stewarding in my presence. It had the large black felt tip pen through identifying details of the sender. And either he allowed me to read it or he put it down. And I read that there was a change from a translucent colour to a black colour, but I read that at speed. But Mr. Simons did say that was the central matter that he was investigating.
At the meeting, did Mr. Simons tell you anything else of his discoveries?
He said that he was also investigating the fire classification data relating to the product. Which I assumed meant the Reynabond PE product. I wasn't clear whether he was talking about the changed core or the panels that were used at Grenfell. And I'm not sure he was entirely clear himself at a fairly early stage what he was investigating in relation to the fire classification data, but I may be mistaken as to what he believed.
Were you at that stage concerned that Mr. Simons, a BBC journalist, had discovered something about Reynabond panels that you should have known but did not know?
Yes, I was concerned.
Let's move on. If we go to BBA 408363, this is an email string. And it starts on page 3 with the email of the 30th of January from Tom Simons to you. Can you see that second half of the screen? And he says, "Dear Brian, thanks again for the meeting yesterday. I wanted to make sure that you had the URL of the document which was publicly available, the 2015 test result. I found it here." And then there's looks like a link to something on the internet. I have been looking further at it today and have realized the significance of the fact that this report sets out test results for both the black and grey version of the product. This shows the company specifically tested both versions, presumably having changed the color. The result overall was C, but there was a differentiation between the two versions. I believe the black did better than the grey, though I'm relying on basic web research on the relevant measurements of fire development, so I'm checking this with an expert. However, given the C rating, and the fact that this was a test after a change, I would assume that if the BBA was not notified of a lower rating, that would be highly relevant, regardless of the other evidence. Hope this helps. Tom. Had Tom Simons referred to the 2015 test results at your meeting the previous day, 29th of January?
I can't remember whether he I don't think he went through in detail fire classification reports, other than that he was in possession of some.
I see. When you see here, as we've just read together, I found it here report underlined in blue, which indicates that there's a web link. What was that? What was the report? What was the site he found the document in?
I'm not entirely clear what that is referring to.
Well, he's sending you the URL of the document that was publicly available, he said, which was the 2015 test result, and he's telling you where he found it. My question to you is, what is that? Where did he find it?
Overall, if I can just say where Mr. Simons and I end up, he was not able to provide to me, nor was I able to get my hands on provenanced material, either from Arconic, so directly from Arconic, or directly from the CSTB. This was one of the issues. I think Mr. Simons was relying upon a well-placed source, one of his, I think a customer. And I don't believe I was ever able to go to a location and find material with a provenance linking it directly to Arconic or to the CSTB.
When you got this email, did you click on the word report that you can see in
I must have done, yes.
What report did that reveal?
As I say, I can't remember specifically what it was, but it was not something directly from Arconic or CSTB. Is my best recollection. It was not from one of those two sources, to the best of my recollection.
Right. Can you remember what it was from, or who it was from?
No, I can't. Subsequently, Mr. Simon sent me CSTB, what appeared to be CSTB reports, with a whole litany of different email addresses and attached them. And I couldn't route anything back definitively to CSTB or to Arconic. And I think this was in that category. But I can't specifically tell you what the email address was at the other end of it. Believe me, can I make it clear to the inquiry, I was very keen to provenance material back to Arconic or to CSTB.
Looking a little lower down the email, you can see that you're told there by Mr. Simons that Reynabond PE was classified a C after this change. Did you understand that to have been a classification in accordance with the European testing regime?
That was the assumption, yes.
Was that your assumption?
Yes, that was that was my assumption.
And did you understand in that moment that classification C was inconsistent with the claim that the standard Reynabond product had achieved a class B, as set out in both the first and the second issues of the Reynabond BBA certificate?
Yes.
Is that something that you found troubling?
Yes.
Did you ask yourself, I wonder how Mr. Simons, a BBC journalist, could have found this out and the BBA had not?
Well, if I can go to the point I made yesterday, just the absolute importance of whistleblowers, and the lack of a good system in this industry to collate this intelligence. So I think Mr. Simons had the advantage of having well-placed sources available to him, whereas I didn't. I was keen to explore what Mr. Simons was providing to me, but the key issue, as I say, was provenance. And I never got to a point where I really understood that these documents emanated from Arconic or CSTB. But as you know, and the inquiry knows, separately, I was trying to pursue these issues directly with Arconic to give me the material that they had, which would be route one to getting the information I needed.
Well, you say that Mr. Simons had the advantage of having well-placed sources available to him, whereas you didn't. Does that tell us that there was something structurally wrong with the BBA, such that it couldn't get hold of underlying test data but someone like Tom Simons could.
Well, again, I am not sure that Mr. Simons ever got his hands, or certainly when I was speaking to him, got his hands on provenance material from Arconic or from CSTB. I may be wrong that he did, but I do not remember receiving anything that had that provenance. So to that extent, we were equally in difficulty, but he had the benefit of more about the balance of probabilities for media and publishing purposes than I had in terms of contract requirement with Arconic. So he could do more with what he had, whereas I felt I needed a bit more substantive evidence about the link to Arconic and to CSTB. But again, I assure the inquiry that I was trying to find this out directly from Arconic, as you know.
Well, I'm not sure that's an answer to my question, Mr. Moore, but maybe we'll revisit it again in due course. Can we look at your response to his email, which you sent on the 1st of February 2018, which you'll find on page 2 of this email run. You say, hello, Tom, thank you for coming to see us. Can you see that there? It's copied to John Alban. Hello, Tom, thank you for coming to see us about this sensitive matter. I'm grateful that you shared the background with us, and we've undertaken to preserve reasonable confidentiality. As I explained, the BBA has to balance its contractual obligations to our clients with our obligations as the UK's leading certification body. We've checked our records, and as a result of doing so, we would wish to discuss the matters you raised with us with our client. I cannot be more specific right now, as it is right that we speak to our client to seek their views. However, and noting that the PE product has been withdrawn from the market, there is not an immediate and pressing need for us to engage with them, but we need to do so as soon as possible. I'll give you a call to discuss when you are proposing to approach the companies, so that as far as possible we ensure our comms with them do not avoidably threaten your story. Can you suggest a good time later today to discuss the timing issue, please? What contractual obligations were you referring to there in respect of Arconic?
That disclosing information about them and their products and our engagement with them without their knowledge or consent was potentially a contractual problem.
Why? Because of confidentiality concerns, contractual obligations of confidentiality?
Yeah, because of confidentiality.
I see. Now, you say that there was no pressing need for you to engage with Arconic because they'd withdrawn PE from the market. That's what you say in the pre-penultimate paragraph. Did it not occur to you at the time that the product, Renabon 55 PE, had been on the market for many years, accompanied by an inaccurate and misleading certificate so far as regards fire performance?
Of course, it had been on the market for a long time, but the immediate and pressing need, the public safety criterion, because it had been withdrawn. So I think what I've said there is technically accurate, and I didn't want Mr. Simon's timescales to be mine, but we did make the point want to deal with them as soon as possible. So that statement is my thinking at the time. Yes.
My question really is, why wasn't there an immediate and pressing need for you to engage with Arconic, given that it for some 10 years previous, Renabon 55 PE had been sold with a certificate that was inaccurate and misleading so far as regards fire performance?
At this stage, of course, I didn't know exactly what was on the building, and we were trying to establish this we've been trying to establish this from the company. We'd had some contact with them, and I was very keen to understand what had been on the building. at that time. There was active discussions going on with Mr. Simons to try and get to the bottom of all this. So there was a pressing need. I don't think it was immediate because there was nothing on the market because they'd withdrawn the certificate. But I did want to get to the bottom of this as soon as possible, as I've said.
What did you mean by ensuring your comms didn't threaten the story, BBC's story?
He was extremely concerned, and this is really the point of this email. Though I couldn't tell him that we didn't know about this black core. It wasn't appropriate to tell him. I didn't want. He was very worried about his story being spiked by the BBA rushing to Arconic. And okay, well, thank you. I wanted to keep reasonable cooperation with him because he seemed to have good intelligence that I wanted. So I wanted to make sure that, as far as possible, our needs did not conflict with his. And as you know, within a few days of this, I was contacting Arconic, but I wanted to clear with him first that I could do so in a way that would not alienate him from us.
Let's then look at how you approach the matter with Arconic. Can we look at the email of the 6th of February 2018 that was sent to Claude Verlet and its follow-up? That we'll find at BBA 3010769. And we'll need to go to page 22 in that document. You'll see this is your email of the 6th of February to Claude Verlet, timed at 17:27. And it's entitled Information from the BBC Confidential. And it reads, Dear Mr. Verlet, the BBA has been contacted by BBC Television about a programme they are planning to broadcast in respect of the fatal fire at Grenfell Tower in London in June 2017. The BBC has informed us that in 2015, Arconic may have made some changes to the PE material in the core of the Rainabond PE product, and which may not have been communicated to the BBA. We've not commented on this to the BBC, but we would like to understand whether or not any changes to the core of the PE product occurred in 2015 and whether or not you say that this was communicated to the BBA. I'd be grateful for your response by the close of business on Monday, the 12th of February, 2018, please. Now, we've seen no response from Arconic to this email, neither in the BBA records nor in any of the Arconic records. Does that accord with your recollection that you never actually got an answer to this email?
That's correct. Though, of course, I kept on at this for weeks and months afterwards. But specifically to this email on that day or in the days immediately following, no, I didn't get a response.
Indeed. And let's go to BBA 3010769, page 24. Two pages on, we can see that you sent a further email to Claude Schmidt on the 14th of February 2018, as you can see there, forwarding your email, information from the BBC Confidential, and you say in the first line you're trying to gain a response and perspective from Arconic. This is sent to Mr. Schmidt, and you've sent him the email you'd sent to Mr. Verlet on the 6th of February. We can see from this email, and indeed the email we've just looked at, that you didn't ask Mr. Verlet about the 2015 classification reports and the Class C for PE, did you?
No.
Why is that?
Well, first of all, I wanted to establish whether there was any substance in this at all. I suspected there was, but I wanted to hear, without giving away more than was prudent at that stage, I wanted to hear what they had to say about it.
Had you agreed with Mr. Simons not to mention it, so that Mr. Simons would be able to continue with his investigations? No,
I didn't agree anything in detail like that with Mr. Simons at all. No.
Why did you not tell the Arconic that you had learnt about the existence of some 2015 classification reports which had achieved Class C and demand an explanation for why you had not been provided with that information or the test reports, and an explanation about why the certificate still said B.
Well, all that was to come. This, as we know, this went on for quite a period of time, trying to elicit this information. At this stage, what did they have to say? Did they even accept? There could have been a perfectly innocent explanation. Wasn't sure it would be, but was trying to draw them out to tell me what they had to say about this issue.
Why the softly approach, Mr. Moore? Why not just tell them what you knew? Not the way I chose to approach this. Get the dialogue going. What did they have to tell me? Did they agree? Did they not agree? Did they have anything to say at all about this? That was my starting point. Mr. Simons may not necessarily have been completely correct. As I say, he didn't have provenance as far as I could see, other than the email about the PE core. And my approach, my strategy was to draw out Arconic to tell me what they wanted to tell me initially. And of course, I would be following it up. Why didn't you send them the link to the report or the URL that Mr. Simons had sent you and asked for an explanation?
No, I didn't think that was appropriate. They would have information. They would send me information directly that they had. There are so many documents swirling around without provenance at this time. As I said before, on the internet, even the journalists and media, no, this was potentially really quite confusing. Arconic, here's the issue. What do you know? And then follow up that with what have you got, was the approach I thought was best.
Now, we know from your statement at paragraphs 14 and 15 that you received no response in writing to this email, but you did get a phone call from Mr. Verley
Yes.
on, I think, the 19th of February, 2018. Can we go to page 5 of your witness statement, please? You see there that in paragraph 50, I'm so sorry, it's escaped from my screen, I've now got it. You say, on Monday the 19th of February 2018, at about 10:30 a.m., I received a telephone call from Mr. Verley. He explained that there had been a change of colour of the PE core from translucent to black. This had occurred in May 2015 and was because of the market finding the black colour aesthetically more pleasing, where the edges of the cladding were visible. When I asked him whether the BBA had been informed of this change, Mr. Verley explained that in, quotes, August 2015, the BBA had visited their manufacturing location and had been advised of this change of colour, but no action had been taken by the BBA. Mr. Verley undertook at my request to email me to this effect. I made a brief note of this conversation in my daybook at the time of the call, and I produced a copy of this note as my exhibit BM2. Now, BM2 is at BBA 30010770. If we can look at that, please. Page 3 of that document. We can find the note on the right-hand side. If you look right on the right-hand side, you can see it says Claude Verley, 10:30 a.m. And then below that, and correct me if I get this wrong, it says change for translucent to black does not affect fire and is an aesthetic issue. You can see the edges, which is not good for the market. So our clients asked us to change to black, which we did. We just go down to the next page, please. Which we did. Can you see top left of the screen? We had a visit in August 2015, and they did not, I think that says, did not tell us about it.
Yes.
The audit, and then it says the auditor something. Can you just read what that says, please?
Yeah, the auditor did not take enough about it.
Right. And then underneath that, changes fire regulations, ? Flat or cassette, nothing to do. Now, in your statement, as we've just seen it, you say that you had a visit in August 2015. Well, this is him telling you this.
Yes.
They did not tell us. Could you clarify what it is that Mr. Verley actually said to you? Did he say they did not tell us, or did he say they did not take enough about it?
He said both of these things. Mr. Verley's English was not the very best. He paused over his words, and some of his phrases were not possibly the way you and I would describe things. His meaning, and what I took from it, was the auditor, they raised with the auditor that there was material in binders and folders, we understand now, and they had told the auditor about this relating to the change of colour from translucent to black and the fire test that went with it. And the auditor didn't tell us to do anything about it. And the auditor did not take the material, did not take enough information about it away with him at the time of the audit. That is what Mr. Verler conveyed to me.
So Mr. Verler was confirming to you in that conversation, at the least, that there had indeed been a change in the composition of the product.
Yes.
Were you concerned about the accuracy of the claims in respect of Renabon PE that had been on the BBA certificate in the light of what Mr. Verler was now telling you?
Yes.
Did you discuss the classification of the PE product with Mr. Verler?
No.
Now, you say in your statement that Mr. Verley undertook to send you an email in relation to the discussion you'd had with him. Is it right to say that he did not, in fact, email you as he had indicated he would?
That's correct.
Did you press him to do so?
No, I think the next I remember is contact from his boss, Mr. Schmidt.
Can we then move on to the story with Mr. Simons again? I say move on, move sideways, same day. BBA 409147. There's a further email chain between you and Tom Simons of the BBC on that day, 19th of February 2018. And if we go to page 2, we can see that he writes to you on that day at 12:05, recladding Brahai Bryant as promised. We've uncovered a series of classification reports resulting from tests commissioned by Arconic/Alcoa between 2011 and 2015. These are attached. The testing was done by the French CSTB, but are not currently available through the CSTB website. As you'll see, in only one test in February 2011 does Renabon PE achieve the B European rating as detailed on the product's BBA certificate. Following that, there were 2 tests in which the product was rated E, possibly because of incomplete tests, and 2 where the rating was C. We do not believe the BBA was notified about these tests, but obviously this is something you're investigating. We've had some contact with the company, though Arconic has yet to give us an on-the-record statement because we have said we are carrying out additional research, which produced the attachment. Our feeling is that for now, we'll wait to see how the company responds to you. It would be helpful if you could let me know what happens your end. Best wishes, Tom. And if we go up the page to page 1, up the exhibit rather, to page 1, we can see that you forwarded this email on. Page 1, please. You forwarded this email on to Valentina Amoroso the same day, in fact, 5 minutes later, 12:10. And you attach a raft of what look like CSTB reports. And you say, and can we have that back on the screen, please? Documents. I'm so sorry, Mr. Moore, the document's disappeared. You'll need to have it back. BBA 409147, page 1. What if something's happened?
Mr. Millett, have we got a problem with putting up documents.
It hasn't appeared
No, it
on
hasn't.
my monitor, and I'm assuming the witness can't see it either. Mr. Moore, am I right? You can't see the document.
I can't see documents.
Right. Well, it may just be that reference then, but it was there. Now it's disappeared. I don't know whether there's a general problem. I don't want to continue to ask questions, Mr. Chairman, without the document, even though in fact. I'll recite the document reference again. It was correct because we had it on the screen. Oh, there it is. Very good.
Right.
Right, good. Now you can see from that there is a raft of what look like reports attached to your email to Valentina Amoroso.
Yes.
Do I take it you got those? It must be the case from Tom Simons.
Yes.
Yeah. And you say, via another coincidence, BBC just forwarded all of these. There would seem to be quite a few that we're unaware of. And there are some 7 CSTB classification reports attached. And they include 4 in particular, and I'll just recite them. There's RA 130333, classification report for Rainabon PE cassette, 4th December 2014, showing class E, and that's at BBA 409151. There was RA 140339, classification report for Rainabon 55 PE riveted system, issued same day, 4th December 2014, classification C S2D0, BBA 409152. There was RA 150200, classification report for Rainabon 55 PE riveted system, 22nd of September 2015, also showing C S2D0, BBA 409153. And also RA 150201, classification report for Rainabon 55 PE cassette system, also issued 22nd of September 2015, also showing classification E, PBA 409154. And you say in your email there would seem to be quite a few that we are unaware of. Do you agree, looking at this, that on the 19th of February you were told in both the email and the attachments that following 2011, Rainabon PE had achieved only an E classification in relation to its rivet form, and an E in respect of cassette, and then later a C in respect of rivet?
Well, as I said before, if you read again what Mr. Simons has said, these are not documents that are necessarily sourced from CSTB. These are open source documents. And at the same time, I think Ms. Amoroso and maybe someone else doing a similar exercise of what is out on the media, what is out on the internet that has provenance to Arconic or to CSTB. There is no doubt that I had suspicions that we had not been given the full picture, but this was not conclusive in its own right. My approach, my strategy was only if it comes from Arconic or only if it comes from CSTB, would it be solid.
But these are CSTB reports, aren't they?
They appear to be, but again, if you look at Mr. Simon's comments, he has acquired them from I know not where.
Well, okay, let's take this in stages. Did you read these reports when you received them?
Immediately then, no, I didn't. I think I can't remember what else I was doing more pressing, but I forwarded them on to Valentin, well, as the named people there who are familiar with this case, for them to look at them.
Did you not sit down with them at least just briefly and compare what's said on these reports with what was said on the certificate?
Certainly not then, but I'm sure at some point that I did, and it is clear that what these documents were saying, if correct, was at odds with the BBA's understanding of Class B for the Rainabon product. But as you know, and I'll come back to it, I was still pushing and continue to push Arconic at the same time to provide us with information which it had. It was the important factor and player in this. With all due respect to Mr. Simons and the BBC, not necessarily information that he wanted to provide to us. It was great intelligence, valuable intelligence, but the most important thing was, what did Arconic have to say about this?
Did you see from these reports that both Rivet and Cassette had achieved classifications different from the BBA certificate?
Yes.
Did that trouble you?
Yes.
Did the BBA consider at that point suspending Arconic's BBA certificate?
But the certificate in respect of PE had been withdrawn, I believe, at this stage, because it was no longer in use for high rise or for other use. So there was no BBA certificate for PE. In respect of FR, there still was. But what I can tell the inquiry at this stage is that the BBA was taking extensive legal advice about the handling of the BBC requirement to get information from us, our contractual obligations to Arconic at that stage, and also making disclosures to public. So our lawyers and our counsel were involved in assisting me and us at this stage.
Did you or anybody at the BBA contact the CSTB directly to verify these reports and ask them whether there were any others that related to Reynobond 55 PE that they had?
Yes, I asked Mr. Rowe and or Mr. Alban to contact CSTB at quite an early stage, because that was the other route. There were two channels of provenance, one from Arconic and one from CSTB. And we had been making inquiries, I believe, through Ms. Amoroso or Mr. Rowe, Mr. Alban, of the CSTB website, which now no longer had material on it. And I understood that either Mr. Rowe or Mr. Alban, maybe both, had contacts at CSTB, which I didn't have, and to see if CSTB would be really willing to release information to us. And the response that I got back was, for various commercial reasons, they weren't willing to assist us, which left Arconic as the primary source of provenance for me, which I continued to pursue.
Did it not come as something of a shock to you to discover that there were all these reports showing dramatically worse classification for Reynobond PE than the certificate had done?
I was very concerned, and the potential for the BBA having been misled. I did that was certainly in my mind now. Well, how could this happen? And also, of course, that the BBA had misled or could be misleading users of the certificates were weighing on my mind at this time. So I had two things to investigate at this stage: the change of colour from PE, from translucent to black, and also the fire classification of the products that had been used at the Grenfell Tower.
Let's go to BBA 409746, please. This is an email that you sent to John Alban and Valentina Amoroso on the 23rd of February 2018 at 12:10. If you can, something's gone wrong.
You've got the wrong.
Yeah, it did not come back. BBA 409746. BBA 409746. I'm sorry, Mr. Moore, about this. I, 'cause 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 BBA 409746. Not MET. BBA. Yes, here it comes. Right, this is an email from you to John Alban and Valentina Amoroso on the 23rd of February 2018. I received a call, you say, from Mr. Schmidt at Arconic re Renobond. See my response below. In summary, he was more interested in the BBC and how we were going to handle inquiries than the substantive matter of whether the BBA had been provided with current data about the fire rating of Renobond PE. I felt that he was somewhat evasive, having referred to matters to his board. So I've given him a week to respond as to what the CSTB fire ratings were and why we weren't told, why we were not told if they were different to our cert value. Also, if there could be issues with any other cert, I think Renobond FR is still certificated. If we get no or no satisfactory answer, I would like to discuss our options. Did you tell Mr. Schmidt in that call that you're referring to there, that you had seen a series of reports generated by the CSTB showing materially worse classifications for Renobond PE than the certificate had historically claimed?
I don't think at any point I put to Mr. Schmidt what we had from the BBC. My strategy was for him to provide me with information. Whilst it may sound fanciful, my experience, if you forewarn people, just bad things can happen. So i.e. hiding, destruction, changing of documents. It was very simple. Arconic, tell me what you've got. Show me what you've got about the Renobond PE product. So no, I wasn't. And I was still troubled by the fact that they claimed that all this had been shown to an auditor. I wasn't convinced that was true. And there was therefore the potential for dishonesty. Now, I'm not making allegations that they were dishonest, just what I was thinking of at the time. So no, I wasn't going to alert Mr. Schmidt or his people. By this stage, there was no real reason why they could not have forwarded to me the material that I'd asked for. So no, I wasn't going to alert him, and I wanted him to provide information to me. That was my thinking, my approach, which of course dragged on for some time after this as well. And you can see, I hope, that I began to reel them in around this to the point where, well, they were deliberately choosing not to provide me with information about the PE product. In my opinion, they were deliberately choosing not to tell me about material they had.
I see. So you made is it right? You made a positive strategic decision not to confront Mr. Schmidt with the reports that you'd had, the materially different classifications that they showed, and demand full open draws disclosure of all fire test data from him at that time.
That's correct. Because I also knew that with such a terrible tragedy that had unfolded, there would be the police and there would be this inquiry coming very soon. And I was not going to affirmatively alert Mr. Schmidt and co. About stuff that they may use potentially to their advantage. So yes, this was my conscious approach. It was either going to be from CSTB or from Arconic. And this other information was helpful intelligence, but it was not definitive unless it come from Arconic.
Given what you told us earlier, that you began to suspect that Arconic were misleading you or stringing you along or being evasive, what reason did you have to think that what they did tell you, pursuant to your strategy would be true or reliable?
Well, step one was to hear what they had to say and get my hands on the material they claimed to have. So recover and retain was the approach that I preferred to take. But I was not going to affirmatively alert them of other inquiries. The BBC is a very capable investigative body. It had its own means and methods to bring information to the public realm. I wasn't going to interfere with that unduly, but I wasn't going to positively alert Arconic.
Now, well, you can see below this email an email that you sent to Mr. Schmidt relating to the call. It's quite a long document. If we can just scroll down to page 2, you'll see it. That same day, 23rd of February at 13:20. And you say, dear Mr. Schmidt, thank you for your telephone call today, clarifying that you would not be commenting to the BBC about matters related to Grenfell, and that the BBC would be undertaking further inquiries before releasing a programme. At your request, I indicated that the BBA does not discuss commercially sensitive information with the media. And then if we go to the next paragraph, you say, from the BBA's perspective, I explained that we had not received a written response from Arconic to the question I posed in my email of 6th February to Mr. Verley about the fire test data related to PE. We've been told that the CSTB has provided a number of reports about the fire performance of the PE product. And if that information is correct, the BBA does not believe that it has seen this information. This would be particularly significant if the ratings were different to that which appeared in our certificate. I'm sure that Arconic will have investigated thoroughly the timeline of this product, and so I would believe that the required information is readily available. Although Renabon PE is no longer certificated, other products are, and we need to understand whether we have included the most accurate available information in them to ensure that our certificates do not mislead any user. I also explained that if there have been historical issues, then provided that they're made known to us, we will work with you to address them where possible. And then you say this, in summary, the BBA requires of Arconic that you clarify to us the position in respect of the fire rating provided by the various CSTB fire reports, if they exist, that relate to Renabon PE, and whether there are issues that may affect other products or systems that are currently certificated by the BBA. And then you give a deadline of 5 p.m. on Friday, the 2nd of March, 2018. And then you say, if it is not provided or without good explanation, the BBA will have to consider whether we continue to have confidence in other certificated products / systems. Now, you set that deadline. That was your demand, wasn't it, for disclosure?
It was a demand for disclosure, yes.
And then if you go on to the next document, you can see Claude Schmidt's response. If we go to BBA 3010769, BBA 3010769, page 29. This is an email from Claude Schmidt on the 28th of February 2018. Thank you for your email. The CSTB does indeed have a number of classification reports to Renabon PE, which have been made publicly available on the CSTB website. When the BBA carried out its last audit on-site in September 2017, we provided binders with those classification reports and underlying tests data for both Renabon PE and FR to the auditor, who indicated to us that for the purposes of his audit, he was not interested in them. Those documents were kept in-house at our Merksheim facility and would have been available to the BBA during prior audits. I'm happy to send those documents to you now if you'd like. And then he answers some other questions. And then at the end says, to avoid any problems, I therefore think it would be best for you to speak to our lawyer, Teresa Hitchcock, at the law firm DLA Piper, CC'd here. She will be in a better position to answer any questions that you have. Now, you deal with this email in your witness statement, paragraph 17. Can we look at that? Page 5 of your statement, please. And you say there, you recite the statement and what's in it. And then in the middle of the paragraph, you say, Mr. Schmidt appeared to be suggesting that the BBA had been provided with the opportunity and means to become aware of changes to the Renabon PE core. But he stopped short of saying that we had been informed. In the same email, Mr. Schmidt also advised that we should deal with his lawyer, Ms. Teresa Hitchcock at DLA Piper, LLP. If we go to the next page of your statement, paragraph 18, you say this by way of extra. I was concerned about the implication of Mr. Schmidt's email, as it inferred that the BBA should have been aware of a change to the PE core, but it was my understanding that we were not aware. There is an obligation on our clients to inform us of changes to a product, not simply to generally direct us towards binders, for example. Now, to your knowledge, Mr. Moore, would technical assessors, such as Sean O'Neill, look at fire classification reports during an audit or ask for them to be produced for inspection?
I'm not certain whether it would apply in every case or in some cases. But particularly if it was said here that, given this very important case, that this company had drawn our attention to material and it hadn't been looked at, then that is very significant.
Did you receive the files or binders which Mr. Schmidt offered to send you?
No, I never received these files, and I don't know if we'll cover it off, but you'll see from the subsequent email chain, I spent a lot of time trying to get my hands on what he had almost promised in that email.
Yes. I think the next thing that happens is that you were invited to meet a representative of DLA Piper, Iconic Solicitors, for a coffee and a chat.
Yes.
And that meeting happened on the 5th of March, 2018, didn't it?
It did.
It happened, I think, at a meeting at a cafe away from your office.
That's correct.
Do you know why that meeting took place at a cafe away from your office and not at your office?
Miss Hitchcock politely declined to meet at our offices.
Why?
Yeah.
Why, did she give you a reason?
No, she didn't. There was some confusion about where we would meet, but wherever we were going to end up, in her view, was going to be somewhere outside a formal building, either hers or mine, and it was going to be for a coffee and a chat.
Why? Why would it have to be away from your offices and for such an informal setting or occasion?
Well, I was concerned about this and I was suspicious about why this would be. So my concerns and suspicions were that this would look like some attempt to cooperate with the BBA and buy time. But I was also concerned if there was misleading to be done, that kind of informal environment would be more conducive. So I was concerned about this.
Now, you tell us in your statement at paragraph 24, and I don't think there's a need to go to it, that it was during this meeting you were told by Ms. Hitchcock that Mr. Schmidt was preparing a file for you of all fire test reports. Is that right?
That is correct.
And is it right, summarizing what happened after that, 5th of March 2018, that despite further requests from you in March and April 2018, neither Arconic nor DLA Piper, its solicitors, ever sent you the full suite of test reports or classification reports for PE or FR Renabon 55?
I certainly saw nothing about PE, and I did receive a bundle of FR, having chased, which is what I then sent off to the inquiry, because I understood the inquiry hadn't seen those. So I did see some more FR material. I don't know if it was everything that they had, but I did receive some more.
Did there come a time when you wondered why it was that you received FR but no PE material?
Well, as time went on, my suspicions were aroused. There was something seriously amiss about the PE and the fire classifications. That was the only conclusion I could draw about this. The other hypothesis I had was that if there was nothing wrong with them and Arconic was just going to make disclosure to the public inquiry and didn't want the embarrassment of disclosure, potentially happening to us when it shouldn't be to us, they should have told us this in clear terms or clearer terms. But I was running more about my suspicion that there was something awry here than there was a legitimate reason for not disclosing it. I may be wrong, but those were my suspicions.
Given your suspicions, why did you not write a formal letter to Arconic demanding that, in compliance with their contractual obligations, they turned over to you all relevant test data and classification data for Renault 55 in PAE and in FR, right the way back to 2008 and before that, when the certificate was being drafted?
Well, by this stage into April, I had made numerous requests. I don't think it could have been clearer what I was looking for. And I was taking legal advice about how to proceed. And then it got to the point in April where I was pleased when we were contacted by the Metropolitan Police Service, the first authority or agency that approached us. And I made my disclosure about my suspicions to the detective who came to see us and expected the Metropolitan Police to take this forward. I was really quite seriously concerned about what may be going on in the background, and I think it required a more formal investigation than I think the BBA could sustain.
Now, on the basis that you'd given Arconic ample opportunity to provide the documents requested, and you were aware that they'd made no full disclosure of the fire classification reports in respect of PE, why did the BBA not take action?
What action? The PE core had been removed. The PE had been removed from the certificate, and the FR certificate was still extant. And I was taking legal advice about that position as to whether that should continue. And when Dr. Lane's report showed that she had other material that we hadn't seen, and we had material that she hadn't seen, that the advice I was acting to meant we should move.
And what did you do?
Which was to suspend and withdraw the certificate for FR.
Indeed. And why didn't you do that at a much earlier time, before the publication, or rather the provision of access to the BBA to Barbara Lane's report on the 2nd of November 2018?
Personally, I would have liked to have done that sooner.
Well, you say personally, I would have liked to have done that sooner. You were, I think by this time, Deputy Chief Executive Officer of the BBA, weren't you?
Yes, I was. But as I say, I was taking legal advice about the situation.
So does it come to this, that even though you had been aware from as early as February 2018, from Mr. Simons, that there were CSTB reports showing a materially lower classification for PE and for FR than the certificate stated, you didn't act to suspend or withdraw that certificate until after the 2nd of November 2018, when you saw Dr. Barbara Lane's report?
When it got to, we've dealt with the CSTP, the Mr. Simons position, which I did discuss with our lawyers about provenance, etc. that they were intelligence, but they weren't evidence. And it was not, yes, it's a fact. It wasn't until Dr. Lane's report came through that the BBA moved to suspend and withdraw the FR certificate. That is a fact.
And do you accept that you could and should have done it far earlier in 2018, at the latest, at the time when you realised that the certificate and the fire test data didn't match?
Well, the only point where the BBA had evidence of that, evidence, not intelligence or not information that was all over the internet, the only authoritative time when the BBA was aware of that was Dr. Lane's report. The Metropolitan Police hadn't been able to help us before that because they were very new into this. And the only authoritative position about what was on the building and what wasn't, and all those factors came into place when Dr. Lane's report came to the attention of the BBA.
Before you saw Dr. Lane's report, did there come a time when you were satisfied that Arconic had given you full disclosure of all relevant test data and classification reports for Rainer Bond 55?
Did there come when I was satisfied?
Yes.
Well, because they hadn't produced the PE material to me, then no. But the PE product was not certificated at that time. Only the FR, and FR material had been provided to the BBA.
Given that there never came a time when you were fully satisfied that Arconic had provided you with all the documents that you had been after for so many months, as you've told us, why didn't you act then at a much earlier stage to suspend and then withdraw the certificate, rather than waiting to see what Dr. Lane had to say about it?
Well, I again, we'd involve the Metropolitan Police in this, who were getting up to speed. And the only time I was absolutely fully sure about what was on the building and the situation with the fire test reports was Dr. Lane. It was at that point that the legal advice was absolutely clear that we could act to suspend the certificate.
Well, do you accept that in acting only to suspend the certificate after the 2nd of November 2018, the BBA acted in a way that was supine and leaden-footed?
No, I don't accept that at all. I don't think that's a fair description. I spent a great deal of time trying to put pressure on Arconic to the best I could to acquire this information. I don't think it is fair or accurate to describe the BBA's approach in that way. We had taken legal advice from the time the BBA contacted us, and were trying to be proportionate. But I never, ever was supine or leaden-footed. Well, leaden-footed is a matter of opinion. I never felt supine towards trying to get information from Arconic that I thought we needed.
So what was it that you were waiting for before taking the decision to suspend or withdraw the certificate?
Specifically, I was very interested in Mr. O'Neill, the auditor who had been to Merksheim and was or was not shown these documents. That to me would have been very significant if he'd said no. I was never shown these documents. Now you'll see in my statement I pressed the Met to try to get to this stage quite soon. I thought he was a very significant witness, but my ability to interview or to investigate would probably entail that I needed to travel to Merksheim and interview a number of people who allegedly saw these documents. That was something I wasn't capable of doing. And it wasn't appropriate because I think that's a matter for formal investigation. So you'll see in my statement that I raised in May, I believe, May 2018, that I thought this would be an important thing for the police service to undertake. And around that point, I was willing to have interceded, because I think that would have dropped another element into the equation about whether we were being misled or not. But I wanted the police service involved in that. And I think it was only September 2018 that the Metropolitan Police began to engage with Mr. O'Neill. And I never saw the outcome of that, which was regrettable. One of the things I should have done was insisted that a member of the BBA be present during that meeting between the Metropolitan Police and Mr. O'Neill when a statement was taken from him. So I didn't do that because I wanted Mr. O'Neill to not feel under any pressure from the organisation at all. If we had been there and had that confirmed, then maybe that would have been, in my view, sufficient. But that was September, October, and it just coincided pretty much with Mrs. Dr. Lane's report. So, there were a couple of things going on that would have helped me come to that determination a little sooner.
Now, both Ms. Amoroso and Mr. Chairman, I note the time. This is my last question or pair of questions, perhaps. Ms. Amoroso and Mr. Nkomo both told the inquiry that it wasn't Mr. O'Neill's job as auditor or technical assessor to collect these sorts of documents. So why would you have thought that he would have had them other than on Mr. Schmidt's say-so?
Well, exactly. If their defence, and again, forgive me, I'm not making allegations, I hope unfairly, against Arconic. But if their defence was that they had made a disclosure to the BBA of fire test reports to Mr. O'Neill at that location, and having offered, I don't know what had gone on, having offered them or pushed him towards them, and that wasn't true, that was very significant. And if Mr. O'Neill had these things pushed towards him, well, that was something that the BBA would be accountable for. So I think it was very important that this very specific thing that they were potentially hiding behind or could help their case should be dealt with. And that's why I thought Mr. O'Neill was very important.
Mr. Chairman, I've come to the end of my prepared questions and it's just gone 1 o'clock.
Yeah.
Immediate moment.
It would. Is this the point at which we would normally have a break for other people to consider questions as well?
Yes, it is. And I was going to suggest that we allied the lunch break with the with my examination of my own notes and giving the opportunity to others to supply.
So was I, but I think it's fair just to explain to Mr. Moore where we've got to. Mr. Moore, as you just heard, Mr. Millett thinks he's reached the end of the questions he wants to put to you. But normally we would have a break at this stage just to give him a chance to check that, and also to give other people who are following the inquiry the opportunity to suggest additional questions. I think you were hoping to get away this side of lunch, but would it be a great inconvenience, I hope it wouldn't, for you to come back at, let's say, 2:05, and then to field any further questions that may arise at that stage?
Thank you, Mr. Chairman. I will be here at 2:05.
All right, and then we'll see then if there are any further questions. And as I said to you before, please don't discuss your evidence or anything to do with it with anyone over the break.
I understand.
Lovely. Thank you very much. 2:05 then, please.
Thank you.